Any mention? Please, Your Lordship. Yes. Lordship, I beg to make a mention of item number 7, Your Lordship. Lordship, I pray this matter may be listed after 2 weeks, Your Lordship. No objection, Lordship.
7. The request made on the petitioner, list the matter after 2 weeks.
Much obliged, Lordship. May it please Your Lordship, I beg to make a mention of item number 2. I humbly pray this matter may be taken up after puja vacations.
This also, same order. Same order. Yes.
Similar prayer for item number 5, Lordship.
Again, Mr. Paul. Item 5, who is the other side?
Lord, we have no objections, Lord.
Yes. This also, same. Yes.
Highly obliged.
Please, Lordship. So I beg to make mention of item 6, Lordship, on behalf of Ms. R. Lordship, legal aid counsel.
Yes.
Bring matter be fixed after vacation.
Why? What is the problem?
She's having some difficulties, Lordship.
6 years, Mr. So has made a request on behalf of made a prayer on behalf of the MS R. Datta, not a legal aid counsel, appearing for the petitioner to adjourn the matter. When? How long?
2 weeks, Lordship.
By 2 weeks.
Highly obliged. Still pray for item 8 as well, Lordship.
Mr. Abraham, there is no objection. They are allowed. Yes.
Item 8 as well, Lordship. Item 8.
Item? No objection.
Similar prayer for item 8 as well.
Item 8 also?
Yes.
You are there, Mr.
Yes.
They are also legal aid counsel.
Legal
okay,
counsel.
That also. Same order. Yes.
Jury cause list, item number 1.
Maybe please Your Lordship.
Yes.
Your Lordship, in fact, what happened, actually we have calculated delay was for 5 days only. And the officer concerned of the registry, what happened, to write a delay of 330 days counted from the first day of the judgment, CGM judgment. That appeal provision is there, that has been forgone. That is what happened here.
The appeal provision is there.
Yes.
So you have not filed an appeal?
Appeal was filed before session judge. Against the session judge order, we have come under revision.
That is okay, but then your application is for condemnation of delay of 330.
That is at the instruction of the office.
How can it be?
That's why I
am
stopping. No, I came to know one officer is there. Your Lordship, he has calculated from the date of the first judgment. Appeal provision done away. In fact, delay of 5 days is there.
So then you have to withdraw this petition, file a correct petition then. That is what you should do. There is no other option.
Only 5 days delay, Your Lordship.
Whatever it is, but the law requires a petition also. If the law says that even 5 days, even for 1 day also we have to. We cannot, until unless there is a proper condemnation application, we cannot do this.
Yes. Because again to file it, because we have to send to take the signature from the jail. He is in jail.
Your petition also, there is no proper explanation how that this delay period should be completed. Nothing is there. This is only 2 paragraphs.
Only two paragraphs. The explanation is paragraph 2, not satisfactory.
Signature from the jail.
Whatever it is.
That was William Nagar. So
no, what do you say? If you say that you apply this thing, you withdraw this application, file a fresh one. It's up to you.
Your Lordship,
otherwise, so long this application
no, only the condemnation if Your Lordship allow, because otherwise I have to send my person to William Nagar jail and get the signatures on the petition.
This you should have seen. So how court can correct it? See.
Only the condemnation I will be rectified.
According to you, what is the thing calculation of this thing?
5 days delay.
How can that be 5 days delay? Just show us. What is the date of
the judgment of order dated 11/7/2024. Session judgment
11
11/7/2024.
Judgment of the lower appellate court.
Session court.
Session.
Sessions Court.
Session.
Yes.
The judgment which is under challenge is
Yes.
dated
Yes. 11/7/2024.
11/7/2024.
2024. Yes.
And what is the date of, what is the last date for filing of this thing, revision?
60 days.
Sessions Court order is not appealable. No, there is no further appeal.
No.
So 60 days. So when 60 days expires?
60 days by 9. 11/9. 11/9/2024. And it was filed on 15.
11/9.
11/9. 60 days.
No, what is this? 7 means, see, you have to calculate the dates. Some month will have 31 days, some month will have 30 days. So your time is 60 days, not 2 months.
2 months.
So calculation has to be for 60 days, not for 2 months.
Not 2 months. 60 days.
So you calculate 60 days when it comes. 11/9 or some other date. So Mr. Mahato, there
Yes,
has to be a
yes.
proper calculation.
6 days over it. It will be 6 days. 6 days delay.
No, you have to be.
Yes.
See, are you sure? Are you?
July 30, 31 days.
July is 31 days.
31 days.
Then from 11 you calculate. 9, 11, 20 days in July.
Yes.
Then comes
Uh,
another 40 days.
yes.
So another 40 days means August, another 31 days. That means you have time September 9th.
9 September 9.
September 9th your 16 goes. So
Yes.
10 this
Yes.
condemnation starts running.
10,
Delay
11,
starts
12,
running.
13,
So
14,
there has to be a
15.
proper calculation. It is not for the court to calculate and give it to you.
Yes.
You have to.
6 days, 6 days.
That is for what you were there.
Yes, yes. I am sorry. 6 days. Only that I may be allowed to correct you, Lordship. Because otherwise, again, I have to sell my junior to get the signature from the William Nagar.
That's the problem. See. How can you act as so mechanically? We have already recorded in our thing, in the last order, that there is a delay of
Last order.
38 days. And that Mr. Lindo was there. It is not that in your absence this order was passed.
Yes.
Yes.
Lordship, if the delay is 333 days, then I have
Objection.
some objection. But if it is only 5
But
6
then,
days,
Mr.
then they
Karmi,
have
you-
the right of appeal.
You could have pointed it out.
Last
It is-
date, it was
it
not
is-
there. It was not mentioned in my continuation application, Lordship.
Judgment and order is dated is 11/7.
11/7.
How come it is 21/7 has been recorded on the last?
That is the CGM court order.
Trial court
Trial court.
judgment.
21/7/2023.
Yes,
Yes.
trial
So
court
that
judgment.
is what has been mentioned in your thing. Yeah, Mohanto, this is everything seems to be.
No, 11/7/24 we have written. Paragraph 1.
The last order it is line 21/7. You should have filed an application for correction of those clerical errors.
Lordships ka
It is for councils to point it out. It is for councils to point it out. Just let's say hard Mr. S.P. Mathur under senior counsel for the petition. Also Mr. Ishkani, learned counsel appealing for the state respondents. Your paragraph, it's submitted by the learned senior counsel for the petitioner that there is miscalculation. Submits that he submits that the period of delay of 333 days, as shown is shown in this application for continuation of delay, is not correct, and has been the result of a miscalculation made in the matter. The learned senior counsel submits that the judgment under challenge in the accompanying criminal revision application was passed on
11/7/24.
2024, and as on the date of institution of the criminal revision before this court, comma, there was only a delay of 5 days. Stop. He submits that in that view of the matter, this condemnation application needs to be corrected before it is taken up for consideration. Stop. Mr. Kharmi, let him correct it.
Yes, Lordship.
Mr. Kharmi, learned additional senior PP has no objection. Stop. Let the petitioner. Then you say. Then you say that the petitioner is allowed to correct necessary correction in the condemnation application. This matter on day after his holiday.
Yes.
On Friday then.
Friday. As you
What's the matter on?
Obliged.
Please, Mr. Mohandas, you should
Yes,
be careful.
yes.
Even the court also is not happy when it passes wrong order.
No, I mean, because
Kindly-
actually it
kindly
came
make
to my
sure-
notice,
make
your
sure
lordship,
whenever-
your lordship, what had happened, it came to my
At least
notice.
a proper-
Initially he gave we have 5 days delay, not 6 days delay. Then the registrar said no, it's a delay of 333 days. So when they asked the office, registrar said that their officer informed them it's a 330 from the first order of the
But
CGM.
then can
Then
we accept,
again he sent to correct, take the
can-
signature.
can we accept that reasoning which you are
No, obviously
doing?
not.
That is
Obviously
what
not.
the problem is.
Obviously not.
So at least whenever a council stands, he should be well informed about all this.
Yes, yes. So, in fact, my colleague, he has already informed the office that it cannot be, but they said no. Our officer told like that. Then I don't like to mention who is the officer, what not. So, it looks very bad on my part, Your Lordship. So, I thought that, anyhow, registry has made it wrong somehow. So, that ought to have
Problem
been
is
known.
that in your petition also there is no proper explanation. That is what the problem is.
Yes.
Normally, we have seen in all other cases when condemnation application comes, it is there explained properly that when
Yes,
is the
Lord.
date of judgment, when the last date expired, and from when
From when the
Yes,
implementation
yes.
start running
period of delay.
till the date of filing.
That,
There is
that-
nothing of that sort. That is why the office is confused. And say supposing if you say something one thing in your petition and the office has a different opinion, then they make a note and they place it before us.
The entire delay has
you are
to be
not
explained.
supposed to be this thing. You're supposed to go by what they say, or they are also not supposed to go by what they say. If they have a different view, they make office note and then we take note of it.
Right.
Anyway, please.
In fact-
make necessary.
will correct that part. Deeply obliged.
See, it should not happen. You see, like
Yes, yes.
problem is that.
Obliged.
He's supposed to, due to difficulties, he's pressing the wire address. Deeply obliged, man.
Hearing item number 3.
Mr. Jha is on the other side. He was here just now. No, these are those matters where they were dismissed from service and discharged on the ground of alcohol dependence, my lord. But there was an interim order, and for last 6 years, on the strength of interim order, they're continuing to serve, my lord.
Yes.
My lord, on the previous hearing, this question came up, my lord, that since they are continuing to serve for almost 6 years, so is there still?
There is always a presumption in their favor.
So, my lord, to that effect, we have filed an affidavit, my lord, saying that your lordship kindly takes up the affidavit. It was filed in December 23. This also is 1 year. First is government Saiju.
Yes.
Primarily para 6, my lord.
Yes.
That the deponent states that during the period after the stay was granted by this honorable court, and while the petitioner is in sheltered appointment.
Just para 6. Yes, please.
It says that the deponent further states that during the period after the stay was granted by this honorable court, and while the petitioner is in sheltered appointment, the petitioner was granted leave on compassionate ground. However, after expiry of the leave, the petitioner failed to rejoin on duty and later voluntarily rejoined on duty after absence of 76 days, and he was awarded 14 days a fine with effect from so and so for the offence. Para 7, my lord. The pursuant to the stay granted by this honorable court, the petitioner has been given sheltered appointment, and fresh medical board medical categorization has not been carried out for the petitioner. Because the stay order, we have not carried out any fresh medical categorization, my lord.
That is
There was no.
the fact remains that he is performing his duty.
He is in sheltered appointment, my lord.
Whatever it is, so you keep him there permanently.
And sheltered appointment cannot be permanent, my lord. Sheltered appointment is only for temporary medically unfit people, my lord. So those
Yeah, so see, once you have allowed him to continue therein, it shows that he has a temporary medical condition, not permanent disability. There is even no. If a permanent disabled person is given sheltered appointment, how he will carry on? There also he will fail. That is what Dr. Majika, at least there has to be some fairness. You see. A person obtained interim order 6 years back. Department has not even bothered to approach court. It is not that
it's not that, my lord. The matter is in the final hearing stage. So
it cannot be right from the beginning. It is not that you approach this court, you have failed in your report, could have been a different thing. It is not that there is nothing to show that you have never ever sought vacation of these things. And this interim order, so far as interim order is concerned, that is also a very small order, a one-line order, not a recent order. That was passed probably without giving you proper opportunity. So would have definitely filed an application for vacating it. So probably the situation did not allow it. Anyway, we will hear the matter and all. Ultimately, the fact remains that is what, and there should not be any problem if somebody is functioning, is able to give his service. Why should you oust him? Just because you do not like him?
it's not that, my lord. But the only case like what I've been instructed, my lord, because when a person a personnel is under medical disability, my lord, we give him a very light duty. Because these are otherwise general duty soldiers, my lord. They are supposed to be on the field, but we give them some temporary appointment in something like maybe hospital or in office, my lord.
We can understand, Dr. Mojika, what you said. What it implies that perhaps this court have understood. If not understood, just tell us. What we can understand, that if a person is suffering from medical condition, you give him very light duty.
Light duty, my lord.
But then once a person is able to, perform light duties also, then you cannot say that he is permanent. He may have partial duty. If it is in your admission that he is performing light duty, that shows he can. So it means there is you have not made out a case for his ouster. When he fails that, then only he becomes a warden. Then you throw him out. So that goes as your admission. This court will take it as your admission that he is able to perform light duties. We'll take it on that.
My lord, he is not supposed to be on light duty, my lord.
But then he is doing it for last 6 years.
He's doing that because we are obeying by the order passed by this
What
honorable
happens? Say supposing some people has temporary medical condition. What do you do with him?
What we do, my lord, we give him light duty for whatever doctor says that review will be after 3 months or 6 months. For that period, we give him a light duty, my lord, and thereafter, again medical examination is done. Depending on the outcome of the second or third medical, whatever doctor says, my lord, either we discharge him.
If he's not been able to improve, then you oust him.
My lord.
That is what is correct.
My lord.
Now for 6 years,
Nothing
you are
is.
kept in this.
Here, what happened, my lord, because the interim order is operating, we are not in a position to carry out the medical check also, my lord.
Do not say that. You have never sought interference with interim order. There is nothing.
Nothing
this
on
interim
bar, my
order.
lord.
The record shows it was passed on the very first day of the motion.
Yes.
Obviously, without giving you an opportunity, you should have filed an application for vacating, seeking vacation of it. You have not done it. So,
My lord, that is a factual situation, my lord. I cannot improve on that.
the-
My only case, my lord, is that
exactly Dr. Majika, you
my
cannot
lord, our only case is, my lord, that order passed by this honorable court should not prejudice us that way, my lord. That is my case. Of course, we did not file an application for vacating, my lord.
What is the question of prejudice? You by your own action, it shows that you are not prejudiced. You are happy to carry on with the course.
We are not happy, my lord.
But in 6 years, it shows happy. Your happiness, your silence for 6 years shows that you are very happy. How many cases are there, Mister?
The two cases, on the file around same time, my lord. In fact, these are
Why
num-
two cases?
two individuals, my lord.
There are two.
Item number 3 and 4.
Okay. These are same. Item number 4 also same.
Same.
Similar situation.
My lord.
I think they are moved on the same day, my lord.
And this is also alcohol dependency
My lord.
from the same unit.
Same unit.
Same minute or that?
Same unit.
And since we were not ready to take him back, so this court will have to pass some order. So for that we have to do hearing. Let us see what case Mr. Jha makes out. And then we'll see. You're ready, otherwise ready for final hearing.
My lord, I require some accommodation, my lord.
Now you are saying you need to get some accommodation.
No, my lord, I was there, my lord, in the other court.
Then it will go after vacation, not tomorrow, day after tomorrow. It cannot be.
After vacation, any day, my lord. Because last 6 years, they have not brought any on record.
What
my
is the
lord.
stand they have taken in their affidavit in opposition?
In their affidavit in opposition, they have taken, my lord, that I am suffering from this and
This affidavit in opposition was filed on which date?
my lord, affidavit in opposition was filed.
After how many days of the passing of the interim order? We'll see, and then how long this has been pending thereafter. Conduct becomes very important in this kind of cases.
It appears, my lord, the writ petition was filed in July 18, my lord.
And the writ petition is filed on, I think, 31 July probably.
Our affidavit is filed on 31 July, my lord.
31 July of 2018.
18, my lord. Writ petition, I don't
Oh.
have the date exactly. my lord.
This is not the writ petition, no. This is a writ petition. Just a minute. Writ petition was filed in July 2018.
Date,
It is probably it is. What is this? There are different dates.
my affidavit, because as per my record, is filed on 31st July 2018, my lord. The affidavit.
And thereafter, you have allowed this matter to remain like this. Writ petition was filed. The affidavit is signed on 10 July 2018.
So, my lord, within 3 weeks we filed our affidavit.
And thereafter it will remain like this.
So, Mr. Judge tactics, my lord. He's delayed the matter for 6 years.
Why blame to me?
I'm not blaming, I'm appreciating.
This is the second round of litigation.
What happened to the first round of litigation?
They impugned order was withdrawn with a justification that all the grievances has been made up. They have filed an affidavit. Grievances has been redressed with.
Your alcohol dependency is still going on or not?
My lord, that's a false.
It's false. Totally. You never touched it, isn't it?
No, my lord, that's being a
You do not know what that item is.
Fuzzy, my lord. That's they initially they give the free issue, my lord, and thereafter they.
Okay, they will have it just immediately after litigation then. Mr. Learned counsel, the petitioner has sought some accommodation in the matter, on the ground of his personal difficulty. Dr. Majika learned DSGI has no objection.
I have some objection with regard to that.
We do not say anything. Dr. Majika learned DSGI has objected to the prayer. Stop. However, since an accommodation has been sought on the basis of personal difficulty, the prayer is allowed. Release this matter after 2 weeks.
3 and 4.
I'll
This no other matter. The other matter also same order.
Same order.
Same.